Right, I have 8 o'clock. Um, Welcome. Can everybody see me and hear me okay? Yes, my microphone is working and you can see me on the video? Wonderful, wonderful. Well, welcome back, everybody. Good to see everyone again. Um, we're continuing our series of looking at great historical American documents. And over the course of the next hour or so, we're going to dive deep into the next document on our course list, Marbury versus Madison. Marbury versus Madison from 1803. Hopefully, you had the chance to read this document, maybe digest it a bit. You may have noticed this document is a little different than perhaps what we've read so far in this series of webinars, and it's probably a little different from a lot of things that you've read before, because this is a Supreme Court opinion. This is a Supreme Court decision, and Supreme Court decisions they're kind of a bit of a different animal than say something like a private letter or a speech or an address, or any other sort of a document that you might encounter, maybe like a newspaper article in the Federalist Papers, for instance. Um, I know that when I started reading Supreme Court decisions way back when, I struggled with it because it's very legalistic language, right? This is what we might call lawyer speak. And so it may take multiple readings just to begin to sort of try to wrap your head around it. Um, as always, I hope if there was a word that you encountered that you didn't know the definition of, that you looked it up and maybe wrote the definition there in the text. Um, there's a lot going on in this Supreme Court opinion. It's written by Chief Justice John Marshall. It was a unanimous opinion. The final verdict was 4-0. You That might sound strange, right? Because we know there's usually 9 people on the Supreme Court, but this was a 4-0 opinion simply because there wasn't always 9 people on the Supreme Court. That number is actually not set by the Constitution, but by Congress, and so the number of justices on the Supreme Court has fluctuated quite a bit over the course of the court's history. But I want to start off with this question: why are we reading this opinion? Right, there are a lot of opinions from the Supreme Court, and in fact, I think in a few months we're going to be reading another one. I think we're going to be reading Brown versus Board of Education from the mid 20th century. This is we're at a very early case, right? Again, noting the date 1803. I just want to start off with this question: what is the importance? What is the significance of this case? I see several of you are jumping into the chat feature. That's good. But if somebody wants to maybe go ahead, you can unmute your microphone and jump into the conversation here. Why is this opinion important? Yeah, please go ahead.
Established the concept of judicial review, which meant that the Supreme Court could declare that laws passed by the legislative branch were unconstitutional.
Yes, Cooper, right?
Yes.
Cooper, keep your mic unmuted for a second, because I just want to maybe ask you to clarify that. What was the first thing you said? That sounded perfectly reasonable to me, by the way. You said something like it established the principle of judicial review.
Yes.
It established the principle of judicial review. So what is judicial review?
It means that the Supreme Court can declare laws unconstitutional.
Yeah, that judicial review, this common constitutional concept, at least now, judicial review states that the Supreme Court has the authority under the Constitution to declare laws of the legislative branch or acts of the executive unconstitutional. And I remember way back when I was studying American government in junior high or high school, my textbook. I wasn't as fortunate as you folks. you guys are reading these original documents. I relied mostly on a textbook when I was growing up, unfortunately. I remember my textbook said that Marbury v. Madison was important because it created judicial review, or it established the principle of judicial review. And something along those lines, I think, is what Cooper has talked about here. And I think there's something to that. I think there's something to that. But how to do this? Does Marshall invent? Does Marshall create out of this decision judicial review? Right, what Cooper told us, right? The power of the Supreme Court to declare acts of the legislative branch, or I'm sorry, laws of the legislative branch or acts of the executive unconstitutional. Does Marshall create that power here? Does he sort of invent it? Where does that power come from?
He basically interprets a line in the Constitution, correct?
Yeah.
More general line, and says that this is what it entails.
Yeah, because I think, just to make sure we're getting off on the right foot here, there's a common misperception, I think, about the significance of this case. And it has, in large part, due to, right, it's due to our textbooks, which I think miss the mark somewhat when it comes to, right, explaining why this case is important. This is, by the way, this is a great example of why you don't rely upon textbooks, why you go straight to the primary documents. Because again, our textbooks tell us that John Marshall sort of created this power of judicial review with this case. That misses the mark, because Marshall is not inventing anything. He's not creating anything. Judicial review as a principle, as a constitutional principle, existed prior to this case. Have any of you guys read the Federalist Papers? Particularly, I think Federalist 78, where Hamilton talks about the courts. In the Federalist Papers, Hamilton talks about the power of judicial review. Hamilton talks about the power that would belong to the Supreme Court to declare laws of the legislative branch and acts of the executive unconstitutional. And Hamilton, like Marshall, will root that principle in the Constitution itself. So Hamilton's not saying it's my interpretation that it's creating this, and Marshall in Marbury v. Madison is not saying my ruling is creating this power. But the ruling that Marshall gives us in Marbury v. Madison is the first time in American history where the Supreme Court actually exercises that power. Yeah, Nora, did you want to jump in? Maybe somebody else. It sounded like somebody else wanted to jump in. By the way, you guys are free to jump into the conversation at any point. We're trying to have a discussion, a seminar style class here, so you're free to interrupt me at any point. Yeah, go ahead, please.
The importance of it is that it sets the precedent, correct?
It sets the precedent.
That he's
yeah,
establishing something new, but he's setting a precedent.
Yeah, this is the first example. This is the first time where the Supreme Court actually uses the power of judicial review to strike down a law passed by Congress. This is the first time in American history where that power is actually exercised by the court. And a law passed by the U.S. Congress is declared null and void because it violates the Constitution. Can we say a little bit more about judicial review? I want to get to the document. I want to get to the document here shortly. But can we state something more about the principle of judicial review as a constitutional principle? I know what judicial review means. Cooper explained it really well. So we've got our definition. But I just want to maybe dive in just a little bit more. We know what judicial review is. That is the power of the court to declare a law of the legislative unconstitutional or an act of the executive unconstitutional. Why does that power exist?
Well, something that's a characteristic of democracy is like separation of power, checks and balances. Mm-hmm. And the judicial review is like a check by the judicial branch on like the executive branch and the legislative branch.
Yeah, that's a great answer, Nick. That is the primary mode for the judicial branch to check the other two branches, right, through the power of judicial review. That is the main check that the judiciary exercises on the other two branches, thus preserving separation of powers. What does that then imply about the Constitution itself, about interpreting the Constitution?
Isn't it like trying to say that the Constitution is the supreme law of the land, like first and foremost? Above like whatever the legislative may try and pass, the Constitution comes first and foremost.
That's it exactly, McKay. That's it exactly. Keep that point in mind, because we'll see Marshall make that exact same argument in this case. Why does the power of judicial review exist, and why does it reside with the judiciary? Because the Constitution is supreme to all legislative acts. The Constitution is supreme to all executive functions. Right? And when the court exercises judicial review, that is not signifying that the court is a more important or a more powerful branch than the other two branches. It merely symbolizes that the Constitution is superior to all three branches.
And it also privileges the amendment process, correct? Saying that
What do you mean?
So in that, if we didn't have judicial review, it'd be a lot easier for the legislative branch to just easily pass laws that might potentially go against the Constitution, whereas with judicial review, you have to go through the whole amendment process to just think that would be technically unconstitutional.
Yeah, that's exactly right. That's exactly right. So judicial review is a way of keeping the legislative branch in check, but in so doing, they're not just keeping the legislative branch or the executive branch in check, they're also preserving the superiority of the Constitution. Is that clear? I think that's clear. If it's not clear, we can do it again. But that's one thing that I want to make sure that we sort of got crystal clear in our minds before we dive into the text. Okay, I'm seeing a lot of positive feedback here in the text, in the chat feature, so that's good. Now that we've established that, let's dive into the case. Let's dive into the text. And again, Supreme Court decisions, they can be hard to wrap your mind around sometimes. A lot of lawyers speak, like I said, but there's a lot going on here. And in fact, what you have in front of you, this is an excerpt of the full case, right? You don't have the full case in front of you because lawyers, politicians, and like professors, sometimes we like to go on and on and on and on and on and on and on. So we're not going to give you the whole thing. We just sort of gave you the important parts here. So the case itself, what are the facts of the case? What's the background of the case? Why is this case before the Supreme Court? What happened to bring this case to the Supreme Court?
So I don't know if people can hear me, if I'm
I
on.
can hear you, Caroline.
Am I?
Yeah.
Okay. So the Adams administration lost to Jefferson in 1800. And so as they were leaving, Adams appointed a lot of new judges who were part of the Federalist Party.
Mhm.
And so one of those judges was to be William Marbury, I believe, but he didn't receive his commission in time. And so after Jefferson moved in, Madison, the Secretary of State, then had to give him his commission, but Jefferson told him not to do it, and so Madison didn't. And then Marbury sued through the Supreme Court in an effort to have Madison give him his commission, I believe.
That's exactly right. That's exactly right. So you've got Marbury, and his first name is, I think it's William, and some other individuals who were appointed by the president to serve as justices of the peace in, I think, the county of Washington and Washington, D.C., as Marshall tells us. Right, so they're going to get a new government job, and Adams appoints them to this position. Those appointments are confirmed by the Senate, as is required under the Constitution. The Secretary of State even affixes the seal and makes it official. But because the appointments were made so late in Adams's term, the commissions weren't actually delivered Marbury and others. And so it was left to, as Carolina tells us quite rightly, it was left to the incoming administration to deliver those commissions. The new president is Thomas Jefferson, and his Secretary of State is James Madison. Right, two names you should be very familiar with, right? James Madison is Jefferson's Secretary of State, and actually, of course, we know will succeed him to the presidency 8 years later. And Madison as Secretary of State and Jefferson as president, they're members of the Democratic Republican Party, right? And this is the first time that the Democratic Republicans have taken over the executive branch of the U.S. federal government. And by the way, just as a side note, you should understand the significance of that fact. The significance of the election of 1800. Right, where the Federalists are in charge, John Adams, right, the Federalist is in charge, and he loses an election to a political opponent, right, to somebody of the opposite political party, Thomas Jefferson and the Democratic Republicans. The significance of that election, I don't think, can be overstated, because for the first time in the history of the world, you have a peaceful transition of power from one political party to another. Adams and the Federalists step aside, and the Democratic Republicans come into power, and not one drop of blood is shed. In other words, ballots have replaced bullets as the ultimate deciders of popular elections. That is a huge feat. And today, when that happens, I mean, we barely notice it. You Americans sort of invented that. That's the first time you have the peaceful transition of power from one party to the other. That is the revolution of 1800. But anyways, I'm again being a professor talking too much. So let me go back to Carolina's very good and very thorough background examination of the case. That's exactly right. So Marbury does not get his commission delivered to him from the Secretary of State, James Madison. And Marbury says, hey, I'm entitled to this under the law. My commission must be delivered. And so what does he do? He sues. And he brings the case before the Supreme Court. The Supreme Court agrees to hear his case. And that's Marbury v. Madison, right? So Marbury is suing Madison in order to get his commission. Is that clear? I think that's clear. But if we need to work on that a bit, we can. Yes?
I have a point to kind of add to what you said about political parties, how there was a peaceful change between the Federalist Party and then the Democratic Republicans. Well, John Marshall, as a Supreme Court judge, I believe he was also a Federalist. So I found it pretty interesting that even though he was in a position to give the case to William Marbury, he actually gave it to James Madison, who was part of the Democratic Republicans. So I thought that was some, I guess, integrity, because he was doing things as they should have been done. It's pretty nice.
And that's sort of exactly what you want in a judge, right? Somebody who's impartial and unbiased and who upholds the law. And you're exactly right. John Marshall is a Federalist. Do you know who appointed him to the Supreme Court?
John Adams?
John Adams. Yeah, John Adams appointed John Marshall to the court. Yeah, please, go ahead, Cooper.
Marshall and Jefferson were cousins, right? And they hated each other?
No, I think you're thinking of Sam Adams.
Or not, sorry, Marshall and Jefferson were cousins and they hated each other.
I'm not sure of that. I'm not sure of that. I don't know.
That's what McCullough said in his biography of Adams, but I don't think they got along.
I'm pretty sure that Marshall and Jefferson did not get along. Yes, I think that that is right. But let's look at what Marshall says here in his opinion. So there's an organization to his argument. He's sort of right. He's an excellent writer. So up front, he sort of he gives you an outline of here's how my argument is going to proceed. And he says we need to answer 3 questions, and then he'll go through, and the rest of his decision is an attempt to answer those 3 questions. So what are those 3 questions? What's the first question? that Marshall says the court needs to answer in this case.
He says, does the applicant have a right to the commission he demands?
Yes. Does Marbury have a right to the commission that he demands? The second question.
If he has a right, and the right's been violated, do the laws of the country give him a remedy?
Exactly. And by the way, this is my second page, very early on in the opinion. That's the second question. If he has a right and that right has been violated, do the laws of his country afford him a remedy? And what's the third point?
If they do give him a remedy, is it a mandamus issuing from this court?
Yes. Is it if the laws of the country do afford Marbury a remedy, is it a mandamus issuing from this court? What's a writ of mandamus? It's a word maybe you don't see every day. So what's a writ of mandamus?
I think a writ of mandamus is basically like a written order that would be telling Madison, you need to do this, you need to give this commission to Marbury. You're like legally obligated to do so from this writ.
That's exactly right, Eric. Yeah. If his rights have been violated and the laws do afford him a remedy, should the Supreme Court issue a writ of mandamus requiring Madison to deliver the commission, right? Basically issuing an order that certain actions are to be that the government is compelled to take certain actions. That's exactly right. Okay, so let's go through this. So point one, what is Marshall's answer? Point one, has the applicant a right to the commission he demands? Yes or no?
Yes.
Yes, yes. Why yes?
Because, let's see, he said it was legally invested in him because he was appointed by the acting executive at the time.
Adams, yep.
Yes. And therefore he does deserve it because he was nominated, appointed, and then commissioned, but he never received that commission, so it's doubtful that it can be followed through.
That's exactly right. That's exactly right. I mean, Marshall even goes back to the text of the Constitution, the second section of the second article of the Constitution, which stipulates that, quote, the president shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, and all other officers of the United States whose appointments are not otherwise provided for, end quote. And Marshall goes through and says, okay, did the president nominate and appoint him? Yes, he did. Did the Senate confirm him? Yes, he did. And then he even gets into, okay, was it authorized? Was it duly commissioned by the Secretary of State? Yes, he did. He even planted the Great Seal of the United States on the document. He has a right to the commission he demands. So the answer to Marshall's first question is yes. Okay, 1 point for Marbury. Looking good for Marbury so far. Question two, if he has a right and that right has been violated, do the laws of his country afford him a remedy? So we already know that he has a right and that right has been violated. And the question is, do the laws of his country afford him a remedy? And what is Marshall's answer to question two?
The answer is yes again.
Mm-hmm. Yes, Nick, why is the answer yes?
Because he has he has a right to the commission, and the laws of the country
Sorry,
well, it's kind of like he has a right to the commission because he was appointed, and if he doesn't get the commission, then it's a violation of that right. So he's like justified to receive a remedy from the laws.
That's the third question. That's the third question. If he's entitled to a remedy, we're just looking at, right, do the laws of the country, actually provide him a pathway to get to a remedy? We're not actually there yet to where yes, we're going to issue a writ of mandamus and give him his commission. The court is merely looking at, okay, what does the law say? So what does the law say according to Marshall? This is right under, and Nick, that was really good. We just need to maybe just add, let's put some meat on those bones. Right under number 2. This is about halfway through the decision. He goes on for a couple of pages explaining why the laws of the country, of the country provide a pathway towards remedying the violation of the right that Marbury has suffered.
I believe it was through the Judiciary Act of 1789 that the pathway existed.
Yeah, exactly. Yeah. The laws on the books, in other words, the Judiciary Act of 1789 provide a pathway for Marbury to take his case to the Supreme Court. Right? And if the court determines that the law has been violated, well, now we're to point 3, right? Because then if the law has been violated, if Marbury's rights have been violated, well, then it sounds like Marbury's well on his way to a win. So the answer to the second question is what? Do the laws of his country afford him a remedy? Absolutely.
Yes.
Absolutely. Okay, so 2 points Marbury. Now we're down to the third point. Things are looking good for Marbury. If they do afford him a remedy, is it a mandamus issuing from this court? Now, if you'll take a look, this is on my page 122, but I don't know if you guys have the same page pagination that I do. Marshall, he actually breaks question 3 up into 2 different parts. Question 3, he says, and this is where you'll see in the text the numbers 1, 2, and 3. It is then the opinion of this court, 1, that by signing the commission of Mr. Marbury, so on and so forth. 2, that having his legal title to the office, he has a consequent right to the commission, so on and so forth. It remains to be inquired whether. You guys all see where I am in the text? He says it remains to be inquired whether 3, he is entitled to the remedy for which he applies. It depends on 1, the nature of the writ applied for, and 2, the power of this court. Okay, so now question 3 is actually broken up into 2 different questions. Find out whether or not he's entitled to the remedy for which he's applying, right? And his remedy is what? A writ of mandamus, correct? Have the Supreme Court tell Madison to deliver my commission. Marshall says, well, to answer that question, we have to answer 2 more questions. The first question is we need to consider the nature of the writ of mandamus that is being applied for. And according to Marshall, does the nature of the writ applied for, let me go back, let me rephrase. In regards to that question, in regards to the question, the nature of the writ applied for, does that provide is he entitled to that remedy? Is Marbury entitled to a writ of mandamus? Yes or no?
I believe Marshall argues yes.
He does.
Because he says, vested legal right of which the executive cannot deprive him. That's how he describes the commission. So that implies that he can't be denied that, and therefore the mandamus would be the right course of action.
That's right. Exactly. He says absolutely. Yeah, the nature of the writ of mandamus right applies in this case. That's sort of the proper legal remedy. Right? We're looking at the violation and how Marbury's rights were infringed. Okay, yes, we can check that box. Does the law provide him a relief? Yes, it does. And the relief provided is a writ of mandamus. Is that the right relief? And Marshall says, yes, it is. This looks like it's going to be a slam dunk for Marbury, right? I mean, every question has fallen his way. There's only one more question, though. And it's the most important one. And it has to do with the power of the Supreme Court. And we go to the text. Make sure we're all on the same page here. This is the paragraph beginning with the Act to establish the Judicial Courts of the United States. I see that? Good. It's right under the bracketed number 2, whether it can issue from this court. So now Marshall is asking the question, can the writ of mandamus that Marbury demands be issued from this court, right? The law says it can be. And Marshall says, yeah, that's the remedy for the violation of Marbury's rights. The question then is, does the Supreme Court have the power to issue a writ of mandamus? Right? Here's what Marshall says. The act to establish the judicial courts of the United States, the Judiciary Act of 1789, authorizes the Supreme Court, quote, to issue writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. Secretary of State, being a person holding an office under the authority of the United States, is precisely within the letter of the description. And if this court is not authorized to issue a writ of mandamus to such an officer, it must be because the law is unconstitutional and therefore absolutely incapable of conferring the authority and assigning the duties which its words purport to confer and assign. This is sort of the first sniff that things are maybe starting to turn against Marbury. Why? What's Marshall saying here so far? Just sort of scratching at the idea. We'll develop it in the next couple of pages more fully, but what is he suggesting here for the first time?
He's intimating that the Judiciary Act of 1789 is actually unconstitutional.
Yeah, because it's that law that would provide a remedy for Marbury. It's that law that would require the Supreme Court to issue a writ of mandamus, right? And thus providing him with his commission. But Marshall is hinting at the possibility that the court would not issue a writ of mandamus if the court determined what?
That it was unconstitutional.
That the law requiring the court to issue the mandamus was unconstitutional. Right? This is the first time where Marbury might be going, uh-oh, winds are changing. Winds are changing. And he goes on in the next few pages to make what argument? What does he say about the provision of the Judiciary Act of 1789? Right? Not the whole thing, but the provision of the Judiciary Act of 1789 that enabled Marbury to bring his claim to the Supreme Court, and that would require the court to issue a writ of mandamus. What does Marshall end up saying? This is the most important part of his decision. This is sort of, over the course of the next 3 pages or so, he really dives into this. So what is Marshall's argument?
Well, he's saying that this part of the Judicial Act is it's at odds with the Constitution.
Yes. It's at odds with the Constitution, which means that the Judiciary Act of 1789, or at least that provision of it that deals with Marbury, is unconstitutional. Is unconstitutional. Why is it unconstitutional?
I believe.
Please go ahead.
Sorry, I believe in the Constitution. It's stated that the Supreme Court has the power over all appellate cases, which means cases that have already been decided and someone's contesting the results. And under this Judiciary Act, Marbury kind of jumped the gun and went straight to the Supreme Court instead of having a lower court go over the case, if I remember correctly.
Something along those lines, yeah. And I think overall that's mostly correct. Let's fill in some of the details, because the Supreme Court doesn't just have appellate jurisdiction. It also has original jurisdiction, but it depends on the case. So, for example, Marbury too many M's. Marshall quotes from Article 3 of the Constitution. If you skip go right where we were reading. If you skip the next paragraph after we stop reading, he goes on to quote directly from Article 3, which says the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. In all other cases, the Supreme Court shall have appellate jurisdiction. Right? So, Calvin, you're right. The Supreme Court mostly has appellate jurisdiction, but it does have original jurisdiction in the particular cases in which the Constitution specifies. Now, let's just take a step back and make sure we define our terms.
So Madison is, I'm sorry, so Madison is not considered a public minister or an ambassador as Secretary of State?
Let's see here. The Supreme Court shall have original jurisdiction in all cases. He's not an ambassador. Other public ministers and consuls, no. In which a case,
why wouldn't he be those? When I look up ambassador or public minister duties, they all list diplomatic duties and Secretary of State.
Because it's Marbury, right? It's Marbury. It's his commission that's at stake, not Madison's.
Oh.
Marbury's the one who's seeking relief, right? Marbury is suing Madison.
Okay.
Is that clear?
Yeah, that clears things up for me.
Okay, but no, that's a great point. That's a great point because that's really easy to see how. Okay, well, doesn't that apply to Madison? But no, the issue isn't Madison, right? Madison's not the one who's taking this case to the Supreme Court. It's Marbury. He's the appellate. Yeah, go ahead.
But Madison is a defendant, but that is not what they're referring to here then.
Exactly. Yeah, because the writ of mandamus would require that Marbury receive his commission, that he be provided relief, that the law would state that Marbury has a right to his commission and the court needs to issue this writ of mandamus to get Marbury his commission. Madison's position, right, as Secretary of State, that's not what is at issue. What's at issue is Marbury's position as a justice of the peace.
Okay, and then the subtlety here also is that in the Judiciary Act that Marshall interprets it the same way Marbury does, with the writ of mandamus applying to both the original and the appellate jurisdiction.
Yeah, now this is where we need to define original and appellate jurisdiction, right? Actually, Marshall defines it here in his case, but before going forward with that issue, I want to make sure we're all on the same page here, figuratively and literally. So what does Marshall mean, or what does the Constitution mean when it speaks of appellate versus original jurisdiction? I just want to make sure we don't lose anybody, because again, this legal jargon can be sometimes hard to follow. So what is, let's see here, what is appellate jurisdiction? Marshall actually explicitly defines that in the case.
He says that it is an essential criterion of appellate jurisdiction that it revises and corrects the proceedings in a cause already instituted and does not create that case.
Good. That's exactly where I wanted to go in the text. That's a few paragraphs down from where we were just reading. But what you just read out there, that's exactly where I wanted to go in the text. So Marshall says appellate jurisdiction. What does that mean? It is the essential criterion of appellate jurisdiction that it revises and corrects the proceedings in a cause already instituted and does not create that case. What does that mean?
Can I
go ahead.
Take a guess. So I would assume that original jurisdiction would be the court that they originally tried or decided upon the case, and then appellate jurisdiction would be like if the defendant or the accused, if they appeal the decision. So it'd be a kind of secondary step, but you have to have the first step first.
That's exactly right. Original jurisdiction, if a court has original jurisdiction in a case, that means they're hearing the case for the first time, right? So they're hearing testimony and evidence and everything that you would, associate with a court case. Appellate jurisdiction, that's an appeal, right? Notice, right, the root word of appellate, right, is appeal. Right. So an appellate jurisdiction means that the court is not hearing the case for the first time. And right in appeals cases, they're not even hearing evidence or testimony of witnesses. They are not there to try the case. They are there, right, as Marshall says, they're not there to create the case. They are there to make sure that all of the proper proceedings, all the proper legal proceedings were followed when the case was originally heard by a lower court or another court. Right, to make sure that all evidence was submitted correctly, that your lawyer wasn't corrupt, or the judge wasn't falling asleep and not paying attention or whatever. That's an important distinction to make, and that's a really important distinction for Marshall here in this case. Why?
So you're saying that the Madison, sorry, what's his name? Marshall is saying that the Supreme Court doesn't have original jurisdiction around this case. It only has appellate jurisdiction for it, right? So it can only have a decision in this case if Marbury is appealing, like he lost a different court case earlier.
Yeah, look, what Marshall ruled in this case is that the provision of the Judiciary Act of 1789 that enabled Marbury to bring his claim to the Supreme Court was unconstitutional because that law passed by Congress in 1789 actually extended the court's original jurisdiction beyond what Article 3 had established. In other words, that law gave the Supreme Court powers that the Constitution did not give it. So according to the law, the Supreme Court is supposed to issue the writ of mandamus, is supposed to demand that Marbury get his commission. But that law violates the Constitution, violates the Constitution's understanding of the jurisdiction of the Supreme Court, because it attempts to apply original jurisdiction, right, to a case. Well, let me say this: it attempts to expand the court's original jurisdiction to a case that would not otherwise apply. So let's again go to the text here a bit. Let's just read. Let's see, right after where we got the definition of appellate jurisdiction. Let's just read some from the case. The very next paragraph. The authority, therefore, somebody see that? Somebody want to start reading there, and you could just go until I tell you to stop.
Sure. The authority, therefore, given to the Supreme Court by the Act establishing the judicial courts of the United States to issue writs of mandamus to public officers appears not to be warranted by the Constitution, and it becomes necessary to inquire whether a jurisdiction so conferred can be exercised. The question whether an act repugnant to the Constitution can become the law of the land is a question deeply interesting to the United States, but happily not of an intricacy proportioned to its interest. It seems only necessary to recognize certain principles supposed to have been long and well established to decide it. That the people have an original right to establish for their future government such principles as, in their opinion, should most conduce to their own happiness, is the basis on which the whole American fabric has been erected. The exercise of this original right is a very great exertion, nor can it, nor ought it, to be frequently repeated. The principles, therefore, so established are deemed fundamental, and as the authority from which they proceed is supreme and can seldom act, they are designed to be permanent.
Okay, stop there just for a moment. Very good. What is Marshall saying here in these selections?
I believe he's saying that no law can contradict the Constitution.
Yeah, the law requires that the court issue the writ of mandamus. But then he says, well, then the question is whether repugnant to the Constitution can actually become the law of the land. If the law is unconstitutional, what are we to follow? the law or the Constitution? And maybe this is right a very simple question. And Marshall sort of right he really emphasizes this so-called simple question, but he emphasizes it because it's fundamental. Right? When the law passed by the legislative branch violates the written Constitution, which should we follow? The law or the Constitution? According to Marshall, should we follow?
Marshall argues that we should follow the Constitution because it is the highest law of the land.
The highest law of the land, and it is the manifestation of the people's will. But then, well, I mean, the law itself, the Judiciary Act of 1789, isn't that a representation of the people's will exercised through their duly elected representatives in Congress? Why shouldn't the law be at least equal to the Constitution? It was created by the people.
I think this is a question of stability.
Okay.
So there needs to be a law of the land that everything sort of refers to or has to fall under. Because if that law of the land can be modified so quickly with the simple passage of a law through Congress, then anything can happen. I guess.
Anything can happen. Can I put that slightly differently? Because that was very, very good. Then the Constitution's meaningless.
Pretty much, yeah.
And the Constitution's meaningless. Who was reading for us?
Joseph London, I was.
Yeah, please. Why don't you you did that so nice. I want you to keep reading for us. You have a good speaking voice here. Right where you left off, skip the next really short paragraph and then pick up with the last sentence of that next paragraph. And then just keep going till I tell you to stop. So you would start with, it is a proposition too plain to be contested.
Okay. Yeah. Let's see. I'm sorry. Where is that?
Okay, so right where you left off, skip the next really short paragraph, right? Then there's a longer paragraph that begins with the government of the United States. The last sentence of that paragraph.
Okay.
It is a proposition too plain to be contested. Do you see that?
I have completely lost. Okay, I found it. Sorry.
Good.
It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior, paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall be pleased to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature, illimitable. Certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation. And consequently, the theory of every such government must be that an act of the legislator repugnant to the Constitution is void.
Okay, you can stop there. So again, this is where Marshall makes that case that Carolina just explained to us, that if a law is repugnant to the Constitution, that law must be null and void. If a law passed by the legislative branch contradicts the plain meaning of the Constitution, then that law not only is unconstitutional, but what that means is that that law is not to be followed. That law, in other words, to be clear, that law is no law at all. If the law violates the Constitution, that law is no law at all, and is therefore non-binding and null and void. That's judicial review. That's judicial review. And so the ruling in the case, who wins this case, Marbury or Madison?
Madison, definitely.
Madison wins. Right? Marbury had won every single point up until that last and most crucial one. Basically, in other words, the law requires that Marbury get his commission, but the law requiring him to get that commission is unconstitutional because it violates Article 3 of the Constitution dealing with the Supreme Court's original jurisdiction. Now, here's my final question. Then I want to take a few minutes and get some feedback from you guys. Why is it the role of the Supreme Court to determine when a law violates the Constitution? Why is it the judiciary that can declare legislative laws and executive acts contrary to the Constitution null and void? Why is this power within the domain of the nature of the judicial authority? If the next two paragraphs, here's what Marshall says. It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So, if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. Why is it the very essence of the judicial duty to say what the law is, whether that law violates the Constitution?
I'm simply assuming that if the Constitution is highest law of the land and sort of by its existence determines whether laws are legal or not, then people who I'm really unsure about this, but
okay, that's okay. Maybe
sorry.
No, you're fine. Don't need to apologize.
I'm assuming that if they this is circular
said,
reasoning, but if their job is to
I was thinking from like a checks and balances standpoint, it wouldn't make sense for the legislative branch to do it because they're already making the laws. And then for the executive branch to do it, that also wouldn't make a lot of sense because they're the branch that enforces the laws. So from a checks and balances standpoint,
yeah, that makes sense to me, right? So the legislative branch makes the laws, the executive enforces the laws, and it's the role of the judiciary then to interpret the law or adjudicate disputes involving the law. Does this theory that the Supreme Court has the right to exercise judicial review, does this mean that the judiciary is superior then to those other branches, to the legislative branch which makes the laws and the executive branch which enforces them? Because that was the concern of the anti-federalists, by the way. Even the anti-federalists knew that the judiciary was going to have this power of judicial review. And like Brutus, for example, one of the anti-federalists said, this is too much power for the courts. This would actually make the courts superior to the other two branches.
I think the framers' position was that the court out of all the branches was the most impartial, and because it was necessary for one of them to interpret the law, ideally the most impartial branch should be the one that gets to do so.
There's something to that, absolutely. They may not be impartial. I mean, they're human beings like the rest of us, and therefore, right, human beings tend to be partial.
No, I'm not saying that they aren't impartial. I'm saying that compared to the executive branch that enforces the laws and the legislative branch that makes them, I mean, the Supreme Court, they don't do either. So they would have less vested interest in whether they were applied or not applied. I don't know.
Yeah, interpreting the law. Isn't that what we were all taught, right, in junior high or middle school, right? That it's the province of the courts to interpret the law. province, that primary duty that is incumbent in the judiciary to interpret the law, according to Marshall, it also means that the courts must have the powers to declare laws contrary or repugnant to the Constitution void. That doesn't mean that the courts are above the other two branches. It merely means that the Constitution is superior to all the branches. And I love the line that he concludes this decision with, right? A law repugnant to the Constitution is void, and courts, as well as other departments, are bound by that instrument. It's not just the courts, right, that are bound by the Constitution, it's everybody. It's all the branches. It's the particular province of the courts, though, to interpret the law, which means to decide when a law violates the Constitution. That doesn't mean that the courts are the only ones who can tell us what the Constitution means. Marshall doesn't go that far. He doesn't say that, right, we're the only ones who can tell you what the Constitution means. All members of the federal government, all members of the executive branch, and all senators and representatives take an oath to preserve, protect, and defend the Constitution. That doesn't mean that the other two branches can simply say, we don't care what the Constitution says, we'll just let the courts figure it out whether or not what we're doing violates the Constitution or not. Right? Marshall would never go that far. Right? It's the responsibility of all government officials to uphold the Constitution, but it's the particular province of the court to keep the Constitution supreme to all of them. I think that's clear. Is that clear? If not, we'll do it again.
I think it is.
Let me just say this in conclusion. We've been talking a lot here about judicial review. Does Marshall ever use the phrase judicial review in this opinion?
Not that I've seen.
No, he doesn't. Does the Constitution actually use the phrase judicial review? No, it doesn't. Not even in the Federalist and Anti-Federalist debates, the phrase judicial review is never used.
They use in law and equity, and didn't Blackstone use equity to mean judicial review or something like that? Fairness.
Absolutely, Jonathan. Just to be clear here, I think you see the idea of judicial review, the concept of judicial review, the principle of judicial review in the Constitution, in the Federalist Papers, in Marshall's decision in Marbury v. Madison, in Blackstone. You don't actually just, my only point is you don't see that phrase. You don't see those words, right? That all our textbooks have like in boldface, right? And then you look it up in the glossary and you get your definition. The first time judicial review actually appeared in print, I did a little digging on this. The first time judicial review, right? This power was actually called judicial review. Wasn't until the late 19th century in some obscure law review essay. But for all intents and purposes, this is judicial review. Right? Marshall's ruling in Marbury v. Madison is the first time that that power is actually applied and a law is struck down as unconstitutional. Marbury v. Madison. We got a couple of minutes here before we have to call it a night. What questions or comments do you folks have?
I have a comment.
Yeah, please, Mrs. Richmond, go for it.
I've often heard that Marshall realized or thought that Jefferson probably would simply ignore his decision if he said, yep, Madison, Jefferson, you did wrong, you're required to give this. And he realized that the Supreme Court was weak as it was at this point, and that this would make it even weaker if they made a ruling and it was ignored. So in a sense, his decision to say, well, I can't give this writ of mandamus because of this other judicial review business, that he could still rebuke Jefferson in the first 2 points, rebuke Jefferson strongly, but then Jefferson didn't have to do anything. And he gave the Supreme Court more power.
That's a great point. Of course, later on, President Jackson will ignore an order of Marshall's. In fact, a couple of them. And so what if Marshall was trying to avoid that possibility, right? Eventually, right, that Jackson posed a problem later on down the road. I mean, that makes sense to me. I don't know. I honestly, I'm not sure if what kind of evidence this to maybe right that Marshall actually considered that, but I mean that makes perfect sense to me. And I think that's actually quite likely. Yeah, that's a good point.
But he could definitely be very rebuking of Jefferson in those first two questions.
Yeah.
Jefferson, you were wrong. Madison, you were wrong.
Yep. And he comes down. I mean, he drops the hammer. Like I said, up until like those last few pages, right? You're thinking this is going for Marbury.
Mm-hmm.
Right? There's no way he can lose this case, and then just the bottom falls out. Wonderful. Well, I see we're already over time, so let me just thank you, everybody, for once again just a delightful, informative seminar. I learned a lot. Thank you very much. You guys are always a treat. Thank you. You enjoy the rest of your evening. I look forward to seeing you all again.
Thank you.
Thanks, everyone. Thanks, Mrs. Richmond.
Thank you. Good night.
Jason?
Yes.
I have a question for you real quick. I didn't want to say this there, but in the Constitution, so it says, in all cases affecting ambassadors and other public ministers.
Mm-hmm.
If I were to find ambassadors and public ministers other places in the Constitution, they would refer to the Secretary of State then? I mean, you must be right, or else ambassadors doesn't refer to them.
Look, well, I mean, my point would be it would right. It's Marbury's commission that's at stake, not Madison's. But is Madison an ambassador or other public minister or consul? He's not an ambassador, right? He's Secretary of State, which is never actually mentioned in the Constitution, and neither is the cabinet, by the way, right? But the first Congress creates Secretary of State, Secretary of Treasury, Secretary of War, and Attorney General.
No, Secretary of State is first diplomat, chief diplomat.
Yeah, but that's a position never mentioned in the Constitution.
Okay.
It's created by congressional legislation.
And then public minister is the same as public official. Is it?
Public ministers and yeah, that's a good question. I think public ministers and consuls, right? I mean, their particular province is always foreign policy, right? So consuls, I mean, even sort of going back to ancient Rome, this is all related to the representation of the United States, right, to foreign nations, to foreign countries. Now, whether or not the Secretary of State falls into that, I mean, I'm tempted to think, maybe because, the Secretary of State, like all other cabinet positions, are appointed by the president and confirmed by the Senate, right? Which, according to the constitutional text you were just reading, that deals with public ministers and consuls. That would be a part of the reason why, okay, right, our cabinet members have to be approved by the Senate, even though the Constitution doesn't explicitly say anything about a cabinet.
All right, that really stumped me. I mean, I really trouble.
Yeah, honestly, I hadn't thought of that much before you brought it up. I mean, it's an excellent point. I think though that the issue is Marbury's commission, right? It's not Madison's commission as Secretary of State that's at issue. It's Marbury's commission as a Justice of the Peace. Right. So you go through the whole case, and right, Madison, I mean, his position as Secretary of State is only sort of tangentially involved because, well, he's the one who would, is appointed to deliver the commission. He's not the one who's actually, right, that the commission actually applies to.
So if I were suing an ambassador from Iran, and it would not, the Supreme Court would not have original jurisdiction.
If you were suing an ambassador from Iran, the Supreme Court would not have original jurisdiction. I think that's right, according to Marshall.
Okay, that was awesome tonight. Thank you.
Thank you. Great questions. I enjoyed that a lot. You guys got me thinking here. This is wonderful. That's a sign of a great seminar.
Good night.
Wonderful. Thank you. Good night.